Hello everyone, my name is Alexander Lehrer, and today we will be discussing the Federal Water Pollution Control Act, also known as the Clean Water Act. In this introduction to the Clean Water Act, we will address the Act's genesis and discuss how the Act has evolved since its passage in the 1970s. We will cover the Act's legislative history, permitting requirements, and some of the key definitions that have become the focal point of litigation over the years. We will also discuss the recent decisions that have expanded the protections offered by the Clean Water Act and what this means for the environmental law practitioner. The goal of today's lecture will be to discuss the history, objectives, and implementation of the Clean Water Act, address key litigated terms, including navigable waters and point source under the Clean Water Act, and the interpretation using legislative history and well-established case law, and provide key practice tips for environmental attorneys filing or responding to Clean Water Act litigation. So as previously mentioned, my name is Alexander Lehrer, and I'm a partner at the law firm of Trank, Isabel, Siddiqui, and Shadanian in Livingston, New Jersey, where I focus on environmental law with a specific concentration in complex environmental litigation, primarily involving emerging contaminants and natural resource damages, as well as regulatory matters regarding site remediation. Now, I am an experienced attorney in matters involving the Clean Water Act, CERCLA, and the New Jersey Spill Compensation and Control Act, also known as the Spill Act. I am licensed to practice law in the state of New York, the state of New Jersey, and the United States District Court for the District of New Jersey. I am a member of the Justice Stewart Pollack Environmental Inn of Court, the New Jersey State Bar Association, the New Jersey Environmental Law Section, the New Jersey Special Committee for Renewable Energy, Clean Tech, and Climate Change, and I'm also a member of the American Bar Association. I am also a contributor to the New Jersey Environmental Law Handbook, and have lectured extensively about the Clean Water Act before the New Jersey State Bar Association on several occasions. So having said all that, let's get into the program. Now, the Clean Water Act was enacted in 1972, but I think it's important to understand water regulation before 1972 and to have a discussion about what water regulation looked like before the Clean Water Act itself. So as a starting point, we are going to go back all the way to 1899, which is one of the first instances of water regulation in the United States. So the first piece of legislation that is important for our purposes is the Rivers and Harbors Appropriation Act of 1899. The citation is 33 U.S.C. Section 401. And this is also known as the Refuse Act. And the Refuse Act is still in place, and it authorized the permit program to permit and protect navigable waters of the United States in the development, construction, and excavation of our nation's harbors. Now, the Refuse Act prohibits the unauthorized obstruction or alteration of any navigable waters of the United States. And that's a quote from Section 10 of the RHA, or the Refuse Act, 33 U.S.C. Section 403. And the law explicitly states that, quote, "It shall not be lawful to excavate or fill or in any manner to alter or modify the course, location, condition, or capacity of any port, roadstead, haven, harbor, canal, lake, harbor of refuge, or enclosure within the limits of any breakwater or the channel of any navigable water of the United States, unless, keyword unless, the work has been recommended by the Chief of Engineers of the Corps of Engineers and authorized by the Secretary of War prior to the beginning of any excavation." So what does this mean? A plain reading of the Refuse Act demonstrates that this was not really aimed at preventing water pollution, or ensuring clean drinking water, or protecting the flora, fauna, or any ecosystems, or even minimal human health standards. Instead, it's plain that this is an act to protect industry and to protect maritime security.